We are on the record in the Ansell matter case D15-521-960D. Please confirm your appearances.
Good morning, Your Honor. Or afternoon. Marshall Willard, 2515 for Irina Ansell, plaintiff.
Good afternoon.
With me is Lorraine Cole. Sorry. Lorraine Cole, bar number
11912. Good morning.
Good afternoon.
Annette Levy of Annette Levy and Associates on behalf of Non-Party Veterans in Politics, Inc., Steve Sanson and Sanson Corporation. My bar number is 12250.
Good afternoon.
Good afternoon.
John Jones, bar number 6699, appearing on behalf of the defendant.
Good afternoon. And I notice we have Mr. Roston here with us as well. Good afternoon. And who else is present?
My name?
Yes.
Samuel Bailey.
Okay. This is a sealed file. I have no problem if...
I don't know who it is, or
I have no idea who this gentleman is.
why he's here.
We don't know.
He's a litigant. I'm assuming he's affiliated with Mr. Sanson.
Yeah.
He's a litigant before me. But listen, I have no problem. I want to be as transparent as possible. In fact, we'll get into that as I go through my decision. So.
Well, this is a closed hearing in a sealed case, and so I was going to ask the court for its directions relating to the Sanson discovery motions that have been consolidated with the pretrial. And if the court wants to hear them first, then they can be heard first, and then Mr. Sanson and his counsel can depart. If you want to hear them last, then I'd ask for them to be excused until we're done.
Well, let me ask Mr. Jones, do you have any objection to having this hearing open to the public?
Nope.
Okay. I'm going to proceed.
We have no objection either.
Okay. All right. Let me swear Mr. Sanson in. If you'd please raise your right hand to be sworn.
You do solemnly swear testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, you may be seated. We are here primarily on two motions. Mr. Sanson's motion to quash subpoena served on Verizon Wireless filed on July 26, 2017. And Mr. Sanson's motion to quash subpoena ducis tecum and deposition subpoena served on Stephen Sanson filed August 4, 2017. There are associated motions that include motions for attorney's fees, plaintiff's motion to compel filed on August 10, 2017. This matter is well briefed, so additional argument is unnecessary. For purposes of establishing a record, however, I do have a few questions to ask the individuals here. I had anticipated if Ms. Ansell and Mr. Ansell were going to be present, there might be some questions for them as well, but it's my understanding neither party is planning on participating in these proceedings today.
Ms. Ansell was in California at school.
Try to call her if we want. I don't
But we could attempt to put her on the phone if the court wishes.
Okay, it's not necessary at this point. First, let me ask Mr. Jones, what is defendant's position with respect to Mr. Sanson's motions?
Well, frankly, Judge, I've found from day one the attempt to conduct discovery that's occurred with regard to Mr. Sanson to be something that probably wasn't even worthy of a response, frankly, because there's no legal basis. I tried to explain to Mr. Willick very clearly that the only reason Mr. Sanson was added to my witness list solely for the May 31 OSC hearing was because after you made your record on the 17th of May, I felt I needed to have the two people who you cited as possibly being improper attempts at influence by Doug Ansell tell you that Doug Ansell had nothing to do with the comments I made to you. Okay, so Kurt Lambeth was in the hallway for the entire May 31 hearing. When we were using up our time, I sent him home. He was going to tell you, I had no idea you were showing up at my house, so how would I have gotten instructions from Doug to try to say something to you? Similarly, I didn't know what Mr. Sanson would say, frankly. I haven't spoken to him about why he appeared in your courtroom or the conversations that you stated happened on the record. I just assumed that I asked my client, did you ask Steve Sanson to ever say anything to Judge Duckworth about your case? And he said, absolutely not. And I said, okay, well then I want Mr. Sanson to show up. I'll ask him two questions, and he can leave, because I felt with an order to show cause, particularly after, you drew certain conclusions in your May 17th sua sponte hearing that were very troubling to me, in that you reached conclusions without having anybody have an opportunity to present evidence on the issue. You drew a conclusion that Doug Ansell was taking action to try to influence you. And
Let me ask you, Mr. Jones, so is your position in representation of Mr. Ansell that in this sealed case with a confidentiality order, that Mr. Ansell did not provide Mr. Sanson with any information about this case?
It's my understanding that Doug has vented his spleen about the behavior of the plaintiff's attorney in this case, which is not precluded under any sealing order. I mean,
But
he hasn't provided him any
specific
documents.
information about this case?
No.
But you did list Mr. Sanson as a witness in this case.
I listed him, in fact, I did a separate witness list for the May 31 show cause hearing. And I informed Mr. Willick of this. I said to him, you know, I was only going to call him as a witness for the May 31 hearing so that I could prove to you, Your Honor, that you were wrong, particularly because in a contempt issue, the credibility of my client was certainly at issue, and I felt on May 17th, you called my client's credibility into issue significantly, and I didn't think you did with a basis. So Mr. Sanson isn't testifying at the financial trial unless, you know, there may be other things filed in this case that bring this May 17th hearing and the whole issue into more sharp focus. But from my standpoint at this point, Mr. Sanson offers no material information. When I informed Mr. Willick that Mr. Sanson was here solely to say that he doesn't take directions from anyone, because I'm pretty sure that's what he would say, even though I've never asked him, that was the only reason I was going to ask. I tried to explain that to Mr. Willick, and Mr. Willick's response was, oh, Mr. Sanson and Mr. Ansell have a very lengthy relationship, et cetera, so on, something along that effect. But it still doesn't rise, in my opinion. And I haven't weighed in because my client can't afford extra pleadings being filed. I didn't file a joinder. I didn't file anything. I don't even know if I read the motion.
Well, let me ask you this. Are any counsel aware of any legal authority that would preclude the deposition of someone who has been named as an exhibit in a case? Is there any legal authority in Nevada on that point, that a designated witness is allowed to refuse to appear?
Well, my response would simply be this. He was named as a witness for one hearing, and that hearing's already occurred.
Well, there are contempt issues that are ongoing. So, again, back to that point, is there any Nevada legal authority that excuses someone from appearing at a deposition when they've been named as a witness and papers filed with the court?
Your Honor, if I may, the authority is that you can't bring someone in, a non-party, I don't even call them a third party, they're non-party to the case, and bring them in, have them sit for a deposition over non-issues. Any kind of issues of contempt, what has he contributed? Worst case scenario, and I can represent to you, he has not heard anything of any value, of any material issues in this case at all.
Well,
nothing of financials, nothing.
That's what needs to be confirmed.
Well,
Why wouldn't the plaintiff
It's
be
set up.
allowed to inquire, because it is a sealed file, there is a confidentiality order that Mr. Ansell insisted on. He's the one who sealed the file. And I want to be clear here. The sealing of files is something that litigants pursue. I'd rather the whole thing be transparent. And I'd rather, but Mr. Ansell insisted that it be sealed. He insisted that a confidentiality order be entered. So that being said, how does the plaintiff know that there hasn't been communication, that there hasn't been information shared? I want to, as part of laying a record today, I want to establish that fact, because that goes to whether or not there is a need for a deposition. But I think to simply brush this under the rug and say there's an individual who is acknowledged in a sworn declaration that he did contact me personally outside of court with specific reference to this case. You're telling me today, as his counsel, that he had no information about that case. I don't know that. Until he testifies, I don't know that.
The reference that was made to you was about Mr. Willick. Mr. Willick is suing Mr. Sanson, and he engages in the same time. Regardless, it would be the same equivalent of me bringing in every friend or acquaintance of Miss Ansell and having them testify that they were never told anything either.
Well,
It
no,
would
but
be the
that-
same thing. Let's say
This
he
is the
found
point.
something, if I may please, Your Honor, just
No,
for the
no,
record.
please.
Let's say he found something out. How has that been made in any way public? How has that been a breach of anything? How does that relate to any issue in the case whatsoever? It doesn't affect financials. It doesn't affect anything. Mr. Sanson and Mr. Ansell have a free speech right. They have the right to talk. Even the sealing of this case was done improperly. And if brought into this case, we're going to challenge the sealing in the way it was done and have it unsealed. And we're going to bring this up with the
that was
Supreme
Mr.
Court.
Ansell's sealing.
I'm sorry?
Mr. Ansell wanted it sealed.
I don't care who wanted it sealed. They have no relationship.
And I'm going to get to that because I appreciate that. And I want to get to the unsealing of the case because I agree with you. I agree that it's in the public interest that we unseal this
And
case. So that
under
we
the
have full
NRS,
transparency.
even if it's sealed, the pleadings are not allowed to be sealed, even as in a sealed case. There's no such thing as a gag order on a case, even in a sealed case. So even if
And that was not part of the order in this case. There's
for
a
some reason,
confidentiality
there's
order that Mr. Ansell insisted on, and your position is that, and I have no problem with that.
Well, if you have no
I've
problem with it, Your Honor, then let's say something was said, which it wasn't, but let's say something was said. How does it affect the trial? Are you going to call someone up and say, by the way, did they mention Mr. Willick to you?
Well,
How's that an issue in the
and
case?
I'm going to get to that, but I need to understand. You're making that offer. I want to hear from Mr. Sanson as to whether or not there was anything discussed about this case, because it ties into how I approach this case. But do you acknowledge that he cashed the witness check?
I'm sorry?
Did Mr. Sanson cash the witness check and not show up for his deposition?
I don't understand what you're
He
saying.
received a $26 witness check, decided I'm not going to show up.
Mr.
I know it's a small
Willick,
amount,
because
but did he?
Mr. Willick was ordered to pay Mr. Willick's fiancée was ordered to pay Mr. Sanson's attorney's fees in a case that was recently dismissed. And so Mr. Sanson said, well, this is part of what they owe me. They owe me the rest too. $26 is about my gas in one or two of
I got
the
it.
hearings. But he's owed many thousands more. For him, it was self-help
Now,
in taking
now,
that
to be
check.
very clear, the comment that was made to me out of court that Mr. Sanson has not acknowledged, it was directed at the court. It involved Mr. Willick, and I get the fact that there's litigation ongoing, and in this case should not be about fostering or advancing that separate litigation. That's not what this case is about. This is between Irina Ansell and Douglas Ansell. But I need to confirm certain things for the record so that I understand exactly what's transpired here. And the comment that was made to me on the phone was, why do you let Mr. Willick get away with so much crap in Doug Ansell's case?
Which is a very valid question, Your Honor.
Well, and that's
And
why
I can tell you just from my own experience in litigating
Okay,
with
so-
Mr. Willick,
so
not
we're-
with this case.
Listen, we're
Though
here-
also in this
Okay,
case
so
now.
we're here today. I'm going to ask some questions of Mr. Sanson because that's what I want to clear up. During that telephone call, as Mr. Sanson has acknowledged, well, let me ask you this first.
I also, if I may make one comment about the legal authority in Nevada. Another court has made an order that discovery is to be stayed in that litigation of
In the
Mr.
civil
Willick
litigation.
against Mr. Sanson and Veterans in Politics. That order to stay discovery in all proceedings is on file with this court as an attachment to our declarations. It would be beyond the scope of this court's authority to now order discovery against Mr. Sanson, particularly when you look at the categories of what's being asked for. It feeds right into Mr. Willick's case and not this case.
And Mr. Levy, if this helps you out, I'm not going to enter any orders today regarding discovery, and I'll get to that point. But do you find, was it appropriate for Mr. Sanson to call me and ask me that question, why do you let Mr. Willick get away with so much crap? Is that appropriate, yes or no?
Well, I think in response to Your Honor's question to him, he was answering it.
Okay.
He doesn't have the legal acumen that you and I would in thinking, well, is this going to be interpreted that way or this way? And for that, I would apologize for my client, but he's not a lawyer. He's not been legally
So you
trained.
acknowledge that's an inappropriate communication?
No, I don't.
So you don't?
I don't, because it was in response to Your Honor's question, and it didn't have to do with a issue in the case.
Well,
I am glad that Your Honor had terminated that so that it wouldn't go any further.
Well, that's why I wanted to ask today, because I did abruptly end the conversation, because it was completely inappropriate. I hung up, and I'll read all of the text messages into our record today. But now that we're here in the open record, which is where the conversation should take place, I should be influenced only by what happens within these four walls.
Of course.
Nothing that happens outside this courtroom should influence me. So, that being said, Mr. Sampson, what crap, to finish that conversation, and that's why I wanted to know, what information in a sealed case with a confidentiality order, what crap have I allowed to finish that conversation that you initiated with me, allowed Mr. Willick to get away with in Doug Ansell's case?
Well, you want me to speak, Your Honor?
Yes, I do.
Okay. What I heard is that Mr. Willick lies, constantly lies, puts it in deposition. He's supposed to be
I
the
want specific information. What
there
specific
was no specific crap. It's just general.
Okay.
This lawyer over there always lies. He throws crap against the wall and hoping something sticks. He's done that in my case. He's done that in several other cases. That's the crap I'm talking about, Judge.
Okay, so
this lawyer shouldn't even be a lawyer.
Stop. I don't need that. So when you concluded your, hey, stop it. Okay, let the record reflect that the witness is scowling at counsel, directing his venom and anger at counsel, which is completely inappropriate.
I
That
object
behavior
to
is not
that.
tolerated in this courtroom. You know better.
I didn't want to be
So
here,
when
Your
you-
Honor.
I didn't want to be here. You filed the motion. This is your motion.
No, he
Your
filed.
Honor ordered,
No, it's a motion to quash.
it's a motion to quash subpoenas that were sent out by Mr. Willick, and I had asked Mr. Sampson not to come, and then we reread your order, Your Honor, that said that you wanted all the parties to come, and I note that he is the only one that came, so that would show you his good faith.
When you concluded your final text message to me stating, so you can understand what direction we are headed, what kind of veiled threat were you making to the court? What
That
did
wasn't
you-
that wasn't a threat, Your Honor. What direction we're headed? Well, I guess you and I think differently. Okay, let me tell you, because I'm the one that wrote the text. I'm thinking what direction I'm headed is how I'm going to go and look into different court cases, which I have been. I've been sitting in here in your courtroom on different matters, and that's what I mean. It was not a threat. It was just I want to see how you rule in other cases, and how you allow the litigants and the attorneys to conduct themselves in your courtroom. That's what I meant.
Okay. All right. So here's where I'm at.
I did have one comment I wanted to make on just a general concept, because this is discovery, and your inquiry of Mr. Sampson about whether Doug may have told him specifics that might violate a sealed file or a confidentiality order. I filed a motion that gave you concrete proof that the plaintiff released medical records obtained in discovery to a third party who she thought was in the news media, and you denied the motion at a hearing. You didn't care. I mean, you didn't even give me a hearing, and I proved that she perjured herself at her deposition about
Mr.
it.
Jones, you had a hearing.
No, you denied the motion for sanctions without a hearing.
No, listen. Here's where we're at.
But how is it relevant now as it pertains to
Listen,
Doug?
I'm done. I'm going to make my findings and conclusion. I don't need anything further. I'm finished.
Here's information that you don't have, because it only occurred in the last 72 hours, that I think you ought to know. We've been conducting depositions, and we now have confirmation from Mr. Tashima that there was a breakfast meeting between Mr. Sampson, Mr. Tashima, and Mr. Ansell. It went on for at least 20 minutes. Mr. Tashima didn't want to listen to the discussions about the divorce because he was only there to talk finances and didn't really want to hear all the things that both Doug and Mr. Sampson were saying. So he wasn't able to repeat exactly what was said. But Mr. Ansell has confirmed that he had a stack of documents this big, and he was going to hand them to Mr. Sampson, and only didn't because Mr. Sampson wouldn't promise not to post them on the internet. And he didn't want that to happen to the documents that he brought to the meeting to discuss with Mr. Sampson.
There was no documents.
This is
example.
just wait.
This is exactly what
I
I'm
want you
talking
to wait.
about.
This is
This
what
guy's
we're
a
talking
liar.
about. This is it.
when you learn to sit back, what I'm telling you, shut up.